This is the fifth presentation of a five-part feature on the remediation and the final rule. Today's presentation is on ensuring rights for HCBS participants. Okay. So to kind of go back over what the rule says, home and community-based settings must have all the following qualities and such other qualities as the secretary determines to be appropriate based on the needs of the individual as indicated in their person-centered service plan. Right? That includes ensures an individual's rights of privacy, dignity and respect, and freedom from coercion and restraint. And that is listed in the final rule regulation there. And if you missed any of the previous trainings on autonomy, privacy, integration, or choice, you can revisit those trainings and slides on the Community Connections website under the Resources tab. All right. So in order to be compliant with the final rule, your agency needs to protect the rights of the person served of the person-centered service plan, and any modifications or restrictions to that to a person's rights must be documented in an individual person-centered service plan and not restrict the rights of other persons served who do not have those restrictions. Right? That is also listed in the final rule regulation. Okay. So what is the relationship between person-centered service plans and the final rule? All right. The final rule is meant to describe how a provider manages a site compliance and declares compliance declares a site protects rights or any other pieces of the final rule to persons served at a comparable level to those not receiving services. So in simple terms, individuals receiving services need to be at the same level, those rights need to be at the same level of individuals not receiving services. Right? So PCSPs, they are a tailored document to the person served and they reflect the needs of that individual. They may be modified but not invalidate site policy. If there is any restrictions due to specific assessed need that would limit or invalidate final rule compliance, this should be reflected in the PCSP and not directly modify the policy of a site. So again, the policy is how you would run your site for no matter who is there. PCSPs can modify and they're based on the specific needs of the individual. Okay, some of the questions in the assessment that covered that, basically your G questions and E questions. So they talk about education, information, grievance, and landlord-tenant laws, and then the responsibilities. So. Other questions on the assessment may pertain to rights of persons served and are not, all of them may not be listed here. How do we inform everyone about their rights? So under the HCBS settings final rule, providers are required to inform people of the rights of HCBS persons served. That includes staff, volunteers, and volunteers can be considered any person not employed by the provider that works with persons served at the facilities can be considered a volunteer. All right. Persons served themselves and family and friends so that they're all aware of the client's rights. All right. How do you inform staff and volunteers? Well, staff and volunteers must complete training and have continuing education opportunities about rights of HCBS persons served and the HCBS settings final rule. So in addition to So this does not take place of training. This is in addition to trainings and continuing education. Staff and volunteers can be notified of those rights through brochures, handbooks, newsletters, emails, and a multitude of other resource guides. All right, so how do we inform persons served, their family, and friends? So providers must provide information about rights to persons served can be done through handbooks, brochures, newsletters, and emails, group meetings, which include PCSPs. These individuals need to be informed upon beginning services at a setting. And then at a minimum, persons served should be informed of their rights annually after beginning services. This is outlined in Article 3063-22, where it states each provider shall offer training at least annually regarding the rights and effective ways to exercise them to each person served, to the guardian if one has been appointed, and to persons' parents and other individuals from each person's support network, where everybody knows. All right, training. So you provide training to staff and volunteers, right? So training should include information about the HCBS settings final rule, including topics like community integration, autonomy, choice, privacy, and rights. Volunteers must be trained as well. Volunteers can be considered community members who donate their time are considered volunteers. Okay, grievance. Under the HCBS settings final rule, providers are required to inform participants of a documented grievance process for when they feel their rights have been violated. So how does a person served notify or file a grievance? All right. Setting must have a detailed process. We're not going to tell you exactly how to do that, but you need to have a process for filing a grievance. Persons served must be aware of the process prior to filing a grievance, and staff must know the process and be able to explain the process to persons served. So if they need help filing a grievance, staff should be able to help them. So we'll talk about landlord-tenant laws. Kansas does have a landlord-tenant law. With that being said, under the HCBS settings final rule, providers are required to offer participants in residential settings a lease agreement. That agreement must follow the laws of the jurisdiction that the setting is in. So in other words, if there are more stringent landlord-tenant laws in your area, other than the state landlord-tenant laws, those need to be followed as well. And they must have protections against evictions and notify persons served of these protections. So they need to be aware of what their rights are. If a person owns their own home, they would have the same rights of a homeowner. Landlord-tenant laws would not be applicable to the homeowner. All right, how do we show compliance? Policies is what we have found to be the best way to show compliance, and that should state clearly how persons served have rights at both residential and non-residential settings. You can also support those policies with handbooks and other documents, and those should inform persons served, guardians, staff, and volunteers that persons served have rights when they receive services at a setting. Pictures and photographs can be helpful. They can support strong policies, handbooks, and other documents. So there's a multitude of ways of showing compliance. All right, so as we put it all together, ensuring information about protecting rights is accessible to all via a policy, handbook, brochure, etc. So they should have access to those items. And the policy should include a date, agency branding, page number, and etc. at a minimum. So when you turn in the evidence for the to the assessment as remediation, you need to make sure and submit the entire policy covering a specific topic to answer the self-assessment question.